It's great to see everyone. I just want to remind everyone to please mute yourself as you come on, just so we don't have any background noise. And we're very pleased to welcome Fred Misilo of Fletcher Tilton, and he'll be discussing special needs trust, estate planning, and important considerations for siblings and caregivers, and in particular, how to facilitate these important discussions. And so thanks for being here today. We're scheduled for an hour, and Fred has just said that he's going to stop early so that you can answer any questions that you have. And so throughout, if you have a question, just please add it to the chat. You'll see a little option down at the bottom for a chat button, and you can just type your question in there. And it's you can see somebody just chatted in there. So just type that question in, and then we'll facilitate questions at the end. And so with that, I will mute myself and turn it over to Fred to introduce himself.
Great. Well, thank you very much, and welcome everyone. Thank you for taking some time out of your lunch hour to come and talk about or learn about some special needs planning and estate planning in general. So I work at Fletcher Tilton. I chair the Trusted Estate Department, which means that I spend most of my time on Zoom calls these days since March, meeting with families around planning for the future of their son or daughter with an intellectual, developmental disability or other situation that requires some trust planning for their lifetime. At its core, a special needs trust is also an estate plan. And so I'll be allowing you to get a glimpse under the hood of an estate planning practice through this process. So let me begin by saluting the malpractice carrier for the law firm, saying that we are making a disclaimer, right? That we're not establishing an attorney-client relationship, that this is primarily education, and that don't rely on any information that you're given here without talking to your own lawyer or to another trusted advisor. So to begin, this is what we're hoping to accomplish, providing some basic estate planning objectives. I think many of you probably have some idea about what estate planning is about, but just making sure that we're level setting the knowledge base. I'll go over a particular part of estate planning is the special needs piece. And for some siblings I've worked with, and I work with a lot because a lot of them are successor fiduciaries with me as a co-trustee. I'm also involved in a number of situations with siblings. And, one of the refrains I hear is that, one, my parents don't tell me what the heck is going on. And second, how do I get them to really take this stuff seriously? Because sometimes there's a whole host of reasons, and I'll go through some of the common rationales, and I'll give you some suggestions as to how to maybe carry that conversation on a little bit further. I'll try to take some of the mystique out of special needs trusts and classify them in basically two categories and explain when they are most efficient, and then I'll talk about some important roles that I think siblings should play. So let's begin by looking at some of the basic estate planning objectives. Of course, there are essentially four. You've heard probably Susie Orman or some other people talk about, you've got to avoid probate, and that's our objective too, right? We want to make sure that upon your passing or upon your parents' passing, your assets do not go into the probate court at the time of death. But estate planning is just not about what happens when you die. It's also prior to dying. So if you become disabled or incapacitated, unable to communicate your decisions, unable to make decisions, you don't want a guardianship appointed for yourself or your parent. You don't want a conservatorship. And how do you avoid that? You do that through planning documents, durable power of attorney, healthcare proxy, HIPAA release. So any good estate plan that's worth its weight in gold must have not only the testamentary documents, the will, and the trusts that pass property over. But it's also has those preliminary, those living documents that we call sort of disability planning documents, the durable power of attorney, HIPAA release, as well as the healthcare proxy under Massachusetts law. The other way that we avoid probate is through the use of living trusts, of revocable trusts. If you own property and you own it in your own name and you pass away, it has nowhere to go, right? Unless there's a co-owner or a beneficiary, it has nowhere to go and it passes down through the probate court. So we use trusts, sometimes tax planning trusts, sometimes just revocable trusts to avoid probate court involvement. Okay, so that's one of the first objectives. The second is to minimize estate administration costs and expenses. Well, by minimizing probate court involvement, we're also doing that as well. We're lowering the cost of administration. There's no delay in the access of funds when someone dies. The other thing to recognize, in case any of you are, many people aren't aware of this, is that Massachusetts is one of 16 states in the country that has an estate tax. An estate tax is sometimes known as a death tax. It taxes the estate of an individual who passes. For our purposes, we'll call that the decedent. So the decedent's estate includes any property they own and control, retirement, house, investment accounts, life insurance, even the death benefit of term life insurance is includable as the assets. Like $1 million life insurance, that's considered something you owned and controlled, that $1 million, even though you may have had $10 in your bank account. You have $1 million life insurance policy, they're going to consider you a millionaire. So what happens in a death tax is that when you're unmarried and you own over a certain threshold, before anybody gets any money, you have to pay the Commonwealth of Massachusetts an estate tax. Now, before I get to what that is, the federal amount is really high. There's a federal estate tax like $12.5 million, and there's portability for the surviving spouse to use any unused deceased spouse's exemption amount. So it goes up to 25 million. Now, realistically, that's half of 1%ers, right, who have $25 million to worry about. But in Massachusetts, to compare that, we're the most hostile state to die from a tax perspective in the country. That's equal to Oregon. So Oregon and Massachusetts has a $1 million threshold. So if your home, your investment, your life insurance, all of those things add up to over $1 million, then we will have to pay the Commonwealth some money. When we have a married couple, one of the things we look at in estate planning is sheltering the $1 million amounts well beyond the confines or the scope of this presentation. But there are lots of people who focus on, okay, we've got a high federal estate tax, therefore we don't have to worry about the Massachusetts estate tax. That's wrong, and it's costly, because if you die unmarried owning $2 million, half of that could be $1 million life insurance policy. The estate tax is $100,000. Okay, you have the $1 million exemption, and you're over $1 million. That's a $100,000 check, real money, real cash, green stuff going to the Department of Revenue that could have otherwise gone to the family. We obviously want to transfer property interest to the next generation. One of the things that we get concerned about is one of the kids going through a divorce. We want to make sure that the inheritance that they're getting isn't going to be tied up in a divorce situation, or one of the children have trouble with alcohol, drugs, but creditors. So there are ways that we need to plan for what you might consider neurotypical children. And of course, now we're also looking at pouring assets over into a supplemental needs trust for someone who needs some financial management, some advocacy, protection, and involved in maximizing eligibility for mass health, for community-based waiver of services, et cetera. housing subsidy. And asset protection, one of the things we're always looking at, I'll get to this a little bit, is, saving the house from the nursing home, long-term care concerns. So all of this is wrapped up in the day-to-day work of a lawyer who's doing estate planning. And my practice happens to spend most of my time with families who have a son or daughter with an intellectual developmental disability. But part of that also involves these other matters as well. So if we turn our attention now to special needs planning, these are the basics. But before I begin, there are four basic principles that I've sort of had in the back of my mind, and I probably should have put them in a slide, is that special needs planning really begins for your parents and for a family when they're living. It's not, doesn't begin when you die. And by that I mean, could we mute if you're participating in the seminar?
I'm actually listening to a webinar on estate planning for disabled people.
Could you please mute anybody who isn't muted right now? There's a, if you look down at the bottom of your screen on the left, please just click the mute button so that we can focus on this. Thank you.
Thank you. So special needs planning begins when you are living. And I have a short example of that. One of my first clients was a gentleman who had a son with Down syndrome who would bring people together to his home on a fairly regular basis to have dinner, drinks, whatever, play cards, and his son was there. His son eventually moved out to his own residential setting, but the group continued to meet and the son would come over. And as I was doing his estate plan, he began to describe this group, kind of like a clique, made up of friends and people who, kind of knew him for a long time. And he said, is there a way for me to pull together this group into my special needs plan so that when I die, these people continue to meet and continue to advise the trustee? And we talked about it, we worked out some language, and we did. And so that has morphed over time into what I use as a trust advisory committee. A committee that people who really don't want to be a trustee, but they have some valuable knowledge and history with the beneficiary. So that's just an example of special needs planning begins while you're living, not when you die. Second basic principle beyond those objectives is that planning really needs authentic relationships with clear expectations. I had a situation, a gentleman who was represented for a number of years through special needs planning and all the rest. And he recently passed away. His daughter called me and said, my dad never talked to me about his plans, never talked to me. And I said, well, I asked him to, but he never did. And so now she's in a situation where she's faced on being a trustee. And so there's a lot of ramp up and a little resentment with regard to, why couldn't I have learned some of this at my dad was living and talk to him about it. So I would just implore you to, if your parents are not sharing their plans with you, I would encourage you to counsel them to do that. It really, really is important for clear expectations. The other part of special needs planning is that change is inevitable. Sometimes, people come in and out of your life in terms of relationships. Sometimes people die, some people get disabled. And one of the recurrent themes that I tell people is that you just can't, this isn't a one and done situation. It's something that's an evolutionary thing. You check in every 3 to 5 years to ensure that the people who are in the plan, who are trust protectors or who are trust advisory committee or guardianship nominees, et cetera, are still relevant. And finally, we've heard the refrain, nothing about us without us. Special needs planning principle must involve and reflect the express preference of the person we're planning for. We're planning for their life, not the life that we would want, but the life that they would want. And it's important to have a letter of intent or a person-centered plan, something that is an adjunct to the trust administration process. So beyond those sort of overarching principles that sort of guide my North Star thinking around these issues, what are the specific objectives that we're trying to achieve? obviously maximizing eligibility for government benefits. These trusts are not accountable resources for purposes of mass health or other means-tested government benefits. That essentially means that a beneficiary doesn't have what I call a gimme power. These trusts are essentially at their core discretionary. So it's not a legal right to the money. It's within the full discretion of the trustee to distribute income and principal. Obviously, we want to promote a desirable, enjoyable, self-directed lifestyle for someone, and our trusts have that language. We also like to use a collateral document called a letter of intent or a person-centered plan to further inform the trustee. And of course, if you have a trust advisory committee who's meeting on a regular basis to assure that you're kind of monitoring how the trust is operating, you're building in a safeguard there to really promote this. The unfortunate thing about many situations that we've come across is that individuals tend to be susceptible to financial exploitation. And so we want to create appropriate safeguards to protect the assets as well as the beneficiary during this process. And there are mechanisms that are within the special needs trust as well as in other documents that provide those protections, and certainly want to ensure that decisions are consistent with the preferences of the person served as well as the family. Over the years, I've heard a lot, people coming in 70s or 80s saying, I haven't done this, and they're apologetic. And I said, that's okay, but it's good that you're here. So if you're here, I have plenty of time to figure it out. I understand that because we all, at least prior to COVID, usually think of death as something that's kind of far out, that's not imminent and absent of sort of immediate mortal threat. We think, we've got time. The problem that, I would just point out with that kind of thinking is that sometimes you run out of time before you realize it. And if you do die without a will, then you're in what's called an intestate situation where the state decides where your money goes, and it goes outright to everybody in the family. So there's no protection, there's asset loss potentially, certainly there's an ineligibility period. And so that creates a tremendous amount of cleaning up work to do, usually by petitioning the court to create an estate plan for an individual who needs one with a disability. And that's time, effort, as well as it's costly. The other problem with this type of rationale is that I will sit with somebody who's really ill, right, who has gotten a bad diagnosis. And one mind is about self-preservation and dealing with whatever illness and loss of capacity they have. And at the same time, they're worried about the future. It's a terrible situation, terrible place to be in. But it happens more often than I would like to admit and say and see. So just encourage it. We're all not all of us are mortal. Many people over 50 have more yesterdays than tomorrows. So it's just a matter of the clock ticking and just being rational about this. Some people say, look, I don't have enough money. It's only for rich people who have tons of dough. I'll just give my money to one of my kids. And this used to be almost a go-to strategy about 30 years ago before special needs planning took off. And, the danger with this is that the person you entrust with that money might die, and their children or their spouse might get it without additional planning on their part. They might get divorced, and the money that's given to them in this morally obligated trust could get wrapped up in the divorce. They could get sued. They might lose a job, run out of money, and be tempted to use the money themselves. So it's just not a good way to plan, just not a good safeguard for people. So if you hear people talking about this, then it's not really a good strategy. If they have a modest estate and they think they can't go to a lawyer, then go to a pool trust. A pool trust every Massachusetts. We have a plan of Massachusetts and Rhode Island. We have the Berkshire County ARC. We have the Greater Bristol County ARC. All three of those pooled income trusts have third-party trusts, and there might be others, but there are third-party trusts that can take this money at a very reasonable, cost. In contrast to the cost that would be employed or the loss of money if this type of planning, this type of option goes awry, and there's a high likelihood that it could. People say it's way too complicated, and I just don't understand it, and I just kind of run away from things I don't understand. That's what lawyers are for, and so it's lawyers. Another word for lawyer is counselors at law. We counsel people, we walk people through. We'd like to be able to partner with other advisors as well to the family. And if it wasn't complicated, you wouldn't need a lawyer or you wouldn't need an advisor. So you don't have to know everything. And that's very similar to we can't agree on things. Sometimes people just end up in analysis paralysis. And I would, if that situation is, it's often because they're worried about something's going to happen 20 years. It may never happen. And we try to focus on people saying, look, think about your estate plan. Think about your special needs plan. If you die, God forbid, within the next 3 to 5 years, make a decision about what you think you want, how you want things to be handled in the next 3 to 5 years, and make a pinky promise to yourself and others that you're going to revise this every 3 years or 5 years. And again, lawyers are great around, if you've been through this, being able around, brainstorming things and helping sort out areas where there might be disagreement, but frankly, there might be ways of resolving this. So this is some of the rationales that I thought might be helpful. Well, we're too busy right now to focus on this. If you've ever read First Things First by Stephen Covey, he talks about the urgency addiction. And listen, during COVID, and many caregivers have been really overwhelmed. It's been a hard 14 or 15 months for everybody. And, we all have a right to be kind of, wanting to get through this COVID thing. But Covey talks about this quadrant of time management. That's the really important stuff, but it's never urgent. Sometimes we focus on a lot of urgent stuff. But if you reflect in the last week, 2 weeks, 3 weeks of the things you were forced to focus on that seemed urgent, you look back and say, really weren't that urgent. I really didn't have to, jump through hoops. So it's sometimes better to begin to remind ourselves about what's really the important stuff to focus on. All right. So what are the basic options? Over here on the left is where I spend most of my time with families planning with their money in the future, setting up a third-party supplemental needs trust. These trusts that we've inherited through the rich common law of Great Britain. They've been codified in the Uniform Trust Code that Massachusetts has adopted, but they are very flexible. They've been around forever. They're old as dirt, and it's very well settled law. Okay, and that's what we use as the framework, as the backbone for special needs planning. So a third-party trust receives assets from parents or extended family members. Often it's life insurance policies or inheritance at the time of death. Now, on this other side are the payback planning options. And these are the things that we often hear about that they're very specialized options. It comes out of a single statute, chapter title 42 of section 1396P, and it authorizes the creation of first-party self-settled trusts that can be created by a parent, grandparent, guardian, court, and a person with a disability. Pool trusts, I just mentioned those. We have 3 recognized ones. There may be others. The 3 that I focus on is Bristol County, Berkshire County, and the plan in Massachusetts and Rhode Island. And then ABLE accounts. Now, ABLE accounts also has a tax-free component under the 529A of the Internal Revenue Service Code. But these are very specific, and don't get confused about these type of federal. Sometimes you hear over 93 or D4A trusts. These are the self-settled trusts. These are created by federal law. They're specific types of trusts, that have some very specific uses, but they're not the default. The mainstay of special needs planning is using a third-party supplemental needs trust. So the important elements of a special needs trust is to full discretion. I said it's full discretion. You can't have a gimme power for the beneficiary, okay? There's no right of withdrawal. You want to think about a trust as, living, of all the estate plans that we do, of all the documents in every estate plan we do, the supplemental needs trust, the special needs trust, and those are two interchangeable words, last the longest. That lasts the lifetime of an individual, whereas these other trusts usually have a time-limited lifespan. So we need to think about, well, who's going to be the trustee in the future? Who's the successor trustee? How are we going to decide, who the future trustees are? Are we going to give future trustees the right to appoint their own successors? Do we need always a professional trustee, or can we have a family trustee? And those are the discussions that an attorney would have in creating this. We also want to make sure that these trusts can't get invaded by creditors. And so we provide protection with regard to these trusts as well. And because there's such discretion given to these special needs trusts, to the trustee, that I believe it's important to have a good number of eyes and ears monitoring. So think about who's going to get the accountings. Trustees have to account to the beneficiary under the Uniform Trust Code, as well as to those persons who are identified in the trust document who are entitled to those accountings. So those are some basic, important elements. The benefits, these are just really, 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 really limited. I mean, there's such a broad array of typical benefits. These are just some. I would suggest to you to think about this in another way, that if you think about what a parent does on a day in and day out basis to support their family member with a disability, when they're gone, who's going to do that? Is it going to be a sibling? Is it going to be another family member? Or are we going to have to pay for that service? Or should we also provide reimbursement and funding for the sibling who's also providing these? One of the things that we've been, really focused on in our trust management area within our firm is ensuring that we maintain proactive contact with our beneficiaries through relationships with the support brokers and others who can provide the casework and the advocacy. And just to follow along, that oftentimes siblings just don't have the time to do, or they may be geographically in a different place than their sibling with a disability. So the trust is there in some ways to almost, to really be the eyes and ears of the parent and the family when the family members are not around to do it themselves. Okay, so now I'm going to remember back to that other slide, the federal Medicaid payback trust. I'm going to just go back just a minute. Okay. So now the Medicaid payback planning options, the self-settled trust, the pool trust, and the able accounts. So that's what I'm focused on here. These are trusts that were created by federal law for specific reasons. It's prior to the enactment of this. When I started practicing back years ago, when I was an outreach worker in the 70s, helping families get onto SSI and Medicaid, is they'd have a $2,000 limit, and if you went over that, you had to spend down this money. You have to buy a lot of, frankly, unnecessary things in order to spend down. Now you don't have to do that crazy spend down like you used to. So if an individual who wants to be entitled to a means tested benefit, wants to avail themselves of that benefit, going over the maximum limit of $2,000, you can put it into a self-settled trust, or you can put it into an able account, or one of these other things. There are things that are the strings that are attached to each one of these. So remember, self-settled trusts have no maximum asset limit. An able account has a $15,000 annual gift limit, and then there's some additional money an employed owner of an ABLE account can contribute, but it's minimal. And the ABLE account has a $100,000 limit for SSI eligibility and a much higher limit for Mass Health. But self-settled trusts have no maximum asset limit. These self-settled trusts also can be used, and I was just working on one of these cases last night, where a parent, a grandparent in this case, was heading into the nursing home, and they have an extra $100,000 that they don't want to use for the nursing home. They want to put aside for their family member with a disability. You can use a Medicaid payback trust to transfer that money for the benefit of a person who meets the definition of disability, and it doesn't create a period of ineligibility for the grandparent. So it's a great public policy strategy. It's a great result for families, rather than have the money spent down. If you think about a parent going into a nursing home, and if they're going to have to use all of their money for their own care, they won't have anything to give to that third-party trust. So we can also use this as a way to ensure that there are assets going over to a family member with a disability. These are emergency options. We don't do these sort of when there's no crisis. We do this only when we need to. Okay, this isn't a sort of a replacement of the third-party trusts. For people who are getting, for moms or dads who are getting child support payments, and you have a family member going into the SSI eligibility period, well, that child support is considered unearned income to that 18 or 19-year-old who's applying for SSI, and we can transfer these monies into the child support into a self-settled trust, and if it's irrevocable, then that assignment does not constitute unearned income of that child support. This is also useful for military survivor benefit pensions, so that the retired military personnel can transfer their survivor benefit plan over to a D4A trust, a Medicaid payback trust, and have their pension money after their death go into this type of trust as well. And sometimes there's just nobody around to serve as trustee, and pool trusts are a great default for there. So I'm going to spend the next 10 minutes really we're honing in on siblings, because I know this is the Massachusetts Sibling Support Network, and if I'm going to present to them, I should be thinking specifically what might be helpful. So in my experience, I've been practicing law now for, I hate to admit it, I got out of law school in '86, so that's 35 years. And prior to that, I was an executive director of a nonprofit organization in Boston, provider organization, where I went to law school at night. We ran programs in Boston area, in Chelsea, Winthrop, and Revere. And then I was also set up some of the first residential programs in South Central and Blackstone Valley in the 70s and very early 80s. I worked at Belchertown State School when I was in college, and just had a lot of experience working in the field over the last 40 plus years. And one of the things that I think doesn't get enough attention either through the provider community is the fact that families still are, in my view, the backbone of a lot of services and supports for individuals with intellectual and developmental disabilities. And sometimes it's by default, sometimes it's one thing that is just comes natural to, of course, I'm going to be there for my brother or sister. But that's a role that should be acknowledged. Again, one of the principles is making sure that people talk about it. I still recall one of the cases that came in many years ago. A gentleman had moved in from out of state to be with one of his children. He brought his adult son with him, and there's another sibling, and one of the siblings said, "Yeah, I'll be there for you." And within a couple months, he left the state and left his sister basically being totally responsible. And as I reflect back on how that happened, I think there just wasn't a lot of communication, honest, authentic communication. And so it's just something that families, obviously, and advisors to families should really think about and talk about. One of the roles that siblings play a lot is trustee, and that's managing the supplemental needs trust when parents die. And you're being called upon to invest the trust assets. You're being called upon to report through an accounting the trust activity, the income, the growth of the principal, the distributions. We're required as a trustee to, make sure that fiduciary income taxes are prepared and filed, making sure that the income consequences to the beneficiary, because distributions of income from one of these trusts is taxable income. So that the tax forms have to be filed with the beneficiary. And there's also the amount of discretionary decisions. Our firm, for the last 20 plus years, and many of you who maybe have attended it, has developed an administration of special needs trust seminar. And for years, we did it on a Saturday, usually the first Saturday in November, for about 4 or 5 hours. Because of COVID last year, we switched from being in person in Marlborough to a 3-part webinar. Normally, we would get about 100 people, 120 people to our Saturday session. People gave up their Saturday to come and sit and listen to a bunch of lawyers and care managers from Fletcher Tilton about what it's like to be a trustee. And we changed that last year, so we set up 3 2-hour webinars in the evening during the weekday, and rather than 100, we had 450 people per session. So it really was a great change, and you learn stuff. I always thought Zoom was a PBS Child's television show, right? So keep on learning. We're probably going to continue to do more webinars in person, even when we get back to be able to be in person. We're going to do more webinars. So if you want to track on our resources page at Fletcher Tilton, we have a lot of information. And if you just track the seminars, it's going to be in usually the first week of November, to learn a lot about what a trustee is. One of the other things we do with trustees is we do co-trustees, so that there's a family member who can serve as a family trustee, or a couple of family members as a family trustee, and then a professional trustee. So you can kind of continue to be a sibling as a family trustee, managing from the heart, and you have the professional trustee managing from the head, and you can meet together on a regular basis to sort of manage in a collaborative fashion. That has worked in a large degree, very much. The Trust Advisory Committee I spoke of earlier, I think is a gold standard in managing a supplemental needs trust, because managing a supplemental needs trust is managing, again, the eyes and ears, not only with the parents' historical information, but it's keeping current, right? And it's involved. There are lots of people who could serve, extended family members, maybe friends. There are some, teachers who have developed direct support professionals who have developed relationships with individuals. They can serve as on a trust advisory committee. Anyone wants to be involved in guiding the trustee. The ultimate decision on these decisions still rests with the trustee, but the trust advisory committee gives some good advice to the trustee. A trust protector is another role for a sibling, which is that, okay, I don't want to be a trustee. Maybe I'll be on a trust advisory committee. Maybe I want to be a trust protector. Maybe one of my siblings could be a trust protector with me. That is making sure that the trustee is doing their job. And if the trustee isn't doing their job, you move the trustee, you change the trustee, you can appoint a new trustee. So in that co-trustee arrangement that I just referenced, where you have a family trustee and a professional trustee, what we'll often do is have the professional trustee be at the basically an at-will trustee, and that the family trustee, if the parents want this, can say, we're going to give you the power to remove the professional trustee because we want to move it to somebody we're more compatible with, or may understand us, or maybe there's been a staffing change with the professional trustee in their organization, and we want to move it. That should be the prerogative, in my view, of the families. I started in my career working with families as an outreach worker 100 years ago, when I had more here than I do now. And I just strongly feel that that's an area that should be within the purview of the family. There may be some who say, I'm really busy. I want to be involved. Is there any way that I can just get regular information? And sure, you could be an authorized information recipient. I mentioned accountants earlier. That is one way for people to stay involved. You can learn a lot about an accounting. You can see what's the investment history, how much is being spent on the beneficiary, what are the expenses, what is the trustee getting paid. Are there things that you can forensically ask information about? And normally there's an ability to then either accept or disagree with the information. Another piece of information authorized is in HIPAA, in health related, or as a durable power of attorney, or as a healthcare agent. And that's something that I'm going to cover basically in the next bullet, which is you can be an authorized decision maker. I'm sure many of the people who are attending this have heard about supported decision making and the move towards helping keep people away from guardianship, seeing guardianship as the last resort, and moving toward lesser restrictive options, including some supported decision making. We don't have a statute now that I know is impending, but what we use in our firm, if we're not going to go with a guardianship, we look at a power of attorney, healthcare proxy, a HIPAA release, and a document that I created which is a limited durable power of attorney, which is an appointment of advocate. Okay, and so you can, as a sibling, be named in these documents to be part of the decision making and getting, as well, in addition to getting information. Obviously, if you've been nominated or serving as a guardian, you have the right to information. You have the right, to make decisions consistent with the terms and conditions and or limitations that are contained in the guardianship decree. So I promised Mary and the organizers of this that I would basically run through my seminar materials. You don't have to look at me. Seminar materials in 45 minutes, and I did. So it's 45 minutes, and so if you have any questions or anything in the chat room, you can read them out to me, and I'll be happy to answer those questions.
Terrific. Thank you so much, Fred. I do have one question in the chat that I will read now. And if anybody else wants to submit a question, you can do that through the chat, or after Fred answers this question, you can unmute yourself and ask in person. So the first question is, can I use funds in a special needs trust to purchase life insurance that leaves the trust as the beneficiary?
Thank you, Mary, for that question. There are times when, and particularly when you have a sibling or a family member serving as a care provider role, I would counsel the family and by asking this question. Okay, I know that you want Linda to be the care provider for your daughter. What happens if Linda dies? Who's going to do it? And often there's like, she's not going to die. Are you kidding me? No. So that's one situation where you may want to have life insurance so that you're insuring. See, life insurance, like any insurance, is you're planning, you're insuring over a risk, right? We get health insurance to pay if we get sick. That's the risk of medical costs. We have car insurance, the risk of getting into an automobile accident. So life insurance is insuring a risk that the named care provider is not going to be able to perform their function, and therefore we should plan for that risk through the use of life insurance. That is a valuable option. I so and I've had clients do this, but it's really in the it's not that common, but I think there's no reason not to, particularly if there is going to be a family member heavily relied on.
That's great. Thank you, Fred.
Well,
So the second question in the chat is from Jean. How different are the laws on trust across the states? My disabled brother is in New Jersey and my dad is in Florida and I am in DL. Is that Delaware? And I am in DL. So how different are the laws across the US?
yeah, well, thank you. That's a really, really good question. We're such a mobile society that we're moving back and forth, and it's a very timely and very relevant question. Um, Even though we have a federal Medicaid law that sets out some basic default guidelines, like the $2,000 resource limitation, most states where they're providing services and supports are state specific. And there are fundamental differences between some states with regard to waiting lists, with regard to prioritization, with regard to interpretation of trusts. So at their core, these trusts should be a discretionary trust, but it's very important that the situs of the trust is going to be determined by where the beneficiary is. Okay, it's where the beneficiary is. The state, the law of that state will be where you're going to be seeking the Medicaid and other means tested benefits. So you're going to be needing to go through that lens. So if the sibling, that your brother is in New Jersey, then you need to speak to a New Jersey special needs attorney who can evaluate a trust that may have been drafted in Massachusetts. It may very well be okay, but it's always good to get someone to review these documents as you cross state lines. And let me just briefly talk about the fact that, well, if you're going to New Jersey, how do you find an attorney who, you know what they're doing or is just dabbling in this? Well, you don't want a dabbler, okay? You don't want me representing you in an otherwise, because you might get convicted because I don't know the law and I'm not good, I don't know that area. So you don't want someone who's doing 3 or 5 different areas of practice. You really want somebody who's focusing on this. So one thing is to check out whether or not they're a member of the National Academy of Elder Law Attorneys, or they're a member of the Academy of Special Needs Planners, or they're part of the Special Needs Alliance. Those are the 3 major organizations that most people in the space I live in and work in operate. Then look at what involvement they do outside of practicing law. Practicing law, just basically their job, and they're not doing anything outside. What is their level of interest? What's their background, etc. And if you do interview someone, ask them what percentage of their practice is part of the special needs practice. So, and always have you or your parents ask how much the consultation is going to cost, how much the plan is going to cost. You have a right to know that right up front.
Terrific, thank you.
Yeah.
So Pamela asks, if you have a will, do you need a trust? And will an out-of-state will hold up in Mass?
Sure. Good question. Yes, really, really inquisitive people. It's great. First, the basic law of conflict of wills, of foreign wills, is that if a will is valid, it was valid in the state in which it was executed, does that mean signed, then it's going to be valid in the state you died in. Even though the laws might be different, there's a what's called comity or a deference given to other states' laws. So if you in Florida and you sign a good Florida will, and you come to Massachusetts and die, if that will in Florida was executed consistent with the law of Florida, it's going to be admitted. Now, here's a question about, remember the very first slide, avoiding probate. A will, at its core, is a document that nominates a personal representative. It used to be called an executor and executrix. That was sort of gender based, but now we go with just the non-gender based, so it's personal representative. Second, it'll often will nominate a guardian, okay, or a conservative of an adult or a child, family member, son or daughter. And third, it'll say where your property is going to go. And there's usually a tangible personal property clause. That's the stuff in the house, the stuff you touch and can give away. And then there's everything else called the residue, land, bank accounts, etc. If you don't have a trust, then the property is going to be subject to probate court administration. That means that any money that you have that's in your name, no one's going to be able to get at it until the personal representative gets appointed. Okay? And then you have to set up a separate account. Then a separate tax identification number. You have to file an account and inventory in the court. Whereas if you have a pour over provision, and so you create a trust, and a trust is nothing more, nothing less really as a property management tool. There are three pieces to it. There's the person who creates the trust, there's the trustee who manages the trust, and then there's the beneficiary who gets the benefit of the trust. For most joint, for most living trusts that we create for ourselves, we're all three of those things. We create it, we're the trustees, and we're the beneficiaries. So it's really a property management tool that when we die, the money stays in the trust and doesn't go to the probate court. And a trust is also like a book. So you have one chapter that says, this chapter one is, this is what happens to this trust when I'm living. And then chapter two says, this is where the money goes when I die. And it just says, okay, upon the death of the grantor, then the property goes over to the next generation, to a supplemental needs trust, for instance. So when you have a will, you should also have a trust, and that the will just basically pours everything over to this trust. And then with regard to the other assets that you have, the life insurance and accounts and real estate, you can direct all of those investments and those assets to that trust while you're living through beneficiary designations and other mechanisms. So I hope that helps a little bit to clarify a will versus a trust. A lot of times a trust looks like a will substitute because the trust actually is owning property and it's also conveying property to the next generation, but doesn't have to go through the probate court because the direction of what happens to the property is within the body of the trust. Okay, then it just continues on. Hope that's helpful.
Perfect. So there's Jean is asking if you would repeat the three associations that you had mentioned in the previous question, that if folks are looking for legal assistance, where should they look? Okay,
so there are two pool trusts these are all managed by nonprofit organizations. Okay, and there are two that are ARC related. One is the Berkshire County ARC, and that's up in Pittsfield. The next one is the Greater Bristol County ARC in southeastern Mass. And then the third is Plan of Massachusetts and Rhode Island, and I think that's based in Newton. Yeah, and I'm sorry if there are others and there are people listening or watching this and I overlooked it. I'm really sorry. It's nothing intentional, but those are the three that come to mind for me.
That's terrific. So I think that those are the questions. I'd like to, on behalf of MSSN, say thank you to everybody who participated with us today. Thank you to PJ for running the show. technologically speaking. Thank you so much. And a very, very special thank you to Fred Misilo for joining us with incredible, valuable, important, critical information that we'll all use moving forward. So thank you again for joining us, and I hope everybody has a great day.
Bye-bye.
Thank you. Bye-bye.
Bye-bye.